Hello, I am here today to answer a question. And the question is, why at the end of a trial in a criminal case does the prosecution get the last word to the jury when they do closing arguments? Because as you know, any law student or lawyer can tell you, the prosecutor makes their closing argument after the proofs are taken, after all the witnesses are done, after all the exhibits are shown, after the judge has instructed the jury. The prosecutor gets to summarize his case or her case and argue to the jury why the defendant is guilty. Then the defense gets to do the same thing, but the opposite, argue why there's reasonable doubt or the crime is justified by some legal excuse, such as self-defense. And then the prosecutor gets rebuttal argument, it's called, or rebuttal summation. And that is a chance for the prosecutor to argue against what the defense counsel just argued, and that's it. And then the case goes to the jury. So actually a lot of appealable claims come up in prosecutor's rebuttal argument because that's when the prosecutor basically lets loose, and they know they can kind of say whatever they want because the defense isn't going to have a chance to say anything against it. And unless a good defense counsel, if they say something they shouldn't say, like if they appeal to race, or if they appeal to national origin, or if they suggest evidence that wasn't presented to the jury, if they suggest special knowledge of such evidence, if they disparage defense counsel, if they rely on the defendant's silence, if they say you should convict him, there's only one person in this room, jury, ladies and gentlemen of the jury, who can tell us what really happened. No, that the prosecutor can't do that. That's objectionable because the prosecutor's saying you should convict him because he didn't speak up and tell his side of the story. And the defendant has a constitutional right to not incriminate himself. It's Fifth Amendment right against self-incrimination, and what that means in practice is the defendant does not have to testify. Not only that, but the jury cannot use that against him. The jury cannot draw any inferences from the defendant's failure to testify. They can't draw any negative inference from that. So those are sort of things prosecutors can do. And the question was, why does the prosecutor get the last word in a criminal case? Because both sides, in a criminal case, usually there's a presumption of innocence, the prosecutor has to prove guilt beyond a reasonable doubt. So, it seems like the defense kind of gets some advantages there. Why does the prosecutor get the last word? Well, that's a good question. And I think it comes down to the fairness principle that our system is based on, and that is the court system at a more fundamental level than a criminal trial, at just a court case in general. A criminal case is a court case. So you have two parties, and two parties are in a dispute. And the two parties are equal under the law. They're both equal. None of them has any rights or privileges that the other doesn't have in a political sense. They might be like obviously the government, the prosecutor has enormous power and wealth at his disposal. And that's one of the reasons that criminal defense attorneys are so undermatched and unfairly matched, because most criminal defense attorneys don't have any money, their clients don't have any money. Criminal defendants are mostly indigent and broke, and they're robbing gas stations for a couple $100s and risking the rest of their life in prison doing it. So they don't have any money. They only have the money that the government in its largesse is willing to give them, and appointed counsel system, and that's very little. So the resources are very unmatched. But in a legal sense, they're supposed to be equal. And in that sense, the judge is the referee. He's not there to take sides. He's just supposed to make sure everything is fair. And so in a criminal case, or any case, you have the one party brings the case. That's called the plaintiff. In fact, even in a criminal case, the prosecutor is called the plaintiff. The defendant is called the defendant, and it's the same in a civil case. You have a plaintiff and a defendant. Only in the civil case, it's usually one person or one corporation suing another person or corporation, which corporations are actually people, so it's one person suing another person, in other words. And so in a criminal case, it's the government, it's the prosecutor, it's the people of the state of Michigan or whatever state, or the United States of America is bringing a suit against John A. Smith, the defendant, bringing a lawsuit. Only they're not charging that the defendant committed a tort, which is a wrong, a civil wrong like negligence, failed to maintain the sidewalk, so I slipped and fell, or I tripped and fell and had an injury. That's a civil suit. In the criminal case, it's the prosecutor saying, Judge, I'm trying to put him in prison. I don't want his money. I want him to go to prison for the rest of his life. And the judge is there to be, okay, well, wait a minute. What legal justification do you have for that? And you have to prove it, because you want to put him away for the rest of his life, or even in prison at all. If you wanted money, we'd just make you prove it a little more than not, like just over 50%. More likely than not. In a criminal case, you got to prove it beyond a reasonable doubt, because you want us to lock this guy up. So they're both the same thing. They're just different aspects of a case that's brought in the court. And I think it's the tradition is that the party who brings the case gets the first word, because they have to say, the burden's on them. You're bringing a case against me. Tell me what the case is about, why you're entitled to any judgment against me, and send me to prison, or send me, make me pay you money. So the other side, once that's done, then okay, now I defend myself. And now you get a chance to say why my defense is wrong. Now, I don't know why you don't get a chance to defend yourself again. That seems like that would be fair. But that's not the tradition that I know of. And it's just the tradition that I've always seen. I've never heard anybody question it. Maybe it's something that should be questioned, and I'm glad you brought that question up. Maybe somebody will want to research that and make a thesis out of it. I think it would be very interesting. And thank you for listening to a little Law 101, something most people should learn in high school, I think, but probably most people don't really think about in that sense. But thanks for listening.